This is Ruffin with Hunt Law, and today we're going to be talking about the crime of burglary in the state of Florida. Burglary is defined under Florida Statute 810.02 as entering either a dwelling, structure, or conveyance with the intent to commit an offense therein. Now, if the property in question was an unoccupied structure or an unoccupied conveyance, then generally speaking, burglary is going to be a third-degree felony, punishable by up to 5 years in Florida State Prison and a fine of up to $5,000. Alternatively, if the property in question was an occupied dwelling, an unoccupied dwelling, an occupied structure, an authorized emergency vehicle, or a structure or conveyance when the offense to be committed is theft of a controlled substance, in those situations, the burglary is going to be a second-degree felony, punishable by up to 15 years in Florida State Prison and a fine of up to $10,000. Now, if in the course of committing the burglary, the offender makes an assault or battery on any person, that makes the burglary a felony of the first degree, punishable by up to life in prison. Also, if in the course of committing the burglary, the offender is or becomes armed within the dwelling structure or conveyance with explosives or a dangerous weapon, then burglary is a first-degree felony punishable by up to life in Florida State Prison. Now, under Florida Standard Jury Instruction 13.1, to prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. First, that the defendant entered a structure, conveyance, or dwelling owned by or in the possession of the person alleged, and at the time of entering the structure, conveyance, or dwelling, the defendant had the intent to commit the crime alleged, which has to be an offense other than burglary or trespass inside the structure, conveyance, or dwelling. If you've been charged with burglary in the Tampa Bay area, call 813-787-4849 for a free case consultation.